For those of you who are not familiar with Ecovis, it's a leading global professional service firm offering comprehensive accounting, audit, legal, tax, and business advisory services to clients worldwide. For more information about Ecovis, see the link in the chat box. As artificial intelligence continues to revolutionize our world, it is crucial to understand the diverse legal landscapes that govern its development and deployment. In our increasingly multinational business environment, companies that aspire to expand and operate more globally must navigate the complex and evolving AI legal framework to ensure compliance and minimize legal risk and liability. Today, we have the privilege to have three distinguished speakers with us, each an attorney expert from their respective jurisdiction, and each a partner in Ecovis International member law firm. Representing the European Union, we have Dr. Roland de Bruyn of Kinhuis Legal in the Netherlands. From the United Kingdom, we are joined by John Bachos of the Moore Barlow law firm. And representing the United States, we have Robert de Brouwer of Pryor Cashman in New York City. This webinar is intended to provide a broad overview of AI regulation in the three jurisdictions. We anticipate this will be the first in a series of webinars, with future sessions delving deeper into the impact of AI regulation on specific industries and areas of law. Our format today includes each speaker presenting for approximately 15 till 20 minutes to discuss AI regulation in their jurisdiction, followed by a Q&A session after all the speakers have presented. There's a Q&A feature in Teams where you can type in your questions in the chat function. The entire webinar should last 1 hour from now on, from start to finish. I will now hand it over to our first speaker, Roland de Bruyn, who will discuss the EU perspective. Roland, it's your turn.
Thank you very much, Richard. I hope everyone can hear me and see my screen. Thanks for the thumbs up. Yeah, I'm Roland and I work as a senior tech and innovation lawyer for Kinhuis Legal, and I combined it with an assistant professorship at Utrecht University. In April 2022, I defended my PhD thesis on regulating innovation in the field of autonomous vehicles. The subject of AI regulation gained ever since more attention over the past 2 years. I'm very happy to be here today and to be able to share some thoughts with you regarding the European perspective on AI and its regulation. I will start with sharing my view on what AI comprises, as opposed or as aligned with the view of the European Union legislator, and how we can find AI in our legal practices today and in the future. Then I'll turn to the AI Act. We will look into the 4 categories that are envisaged by the regulator and how providers and employers will have to comply with an entirely new regime of norms and standards. Thirdly, I'll illustrate the enforcement mechanisms, both from a public and a civil end. Then, what is AI? The concept of autonomous intelligence consists of 3 elements, actually: artificiality, autonomy, and intelligence. Artificial is anything non-human, thus machine-based. Etymologically, the word autonomy derives from ancient Greek. Autos translates as self, and nomos translates as law. Taken together, autonomous indicates living under one's own laws, independent of persons and states. It can be argued that humans, as well as systems, artificial entities, can be to varying extents autonomous. Autonomous systems furthermore characterized as intelligent also to varying extents. Intelligence can be perceived as the ability to adapt one's behavior to fit new circumstances. which encompasses the ability to learn, to reason, to solve problems, to perceive and understand language. And this machine learning forms one of the core components of a systems intelligence. Well, these elements are all reflected in the Union legislator's definition. In the AI Act, an AI system is stated to be a machine-based system that's designed to operate with varying levels of autonomy that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs, such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. We have seen, of course, ChatGPT rise as a rising star, driven by AI. You will all know ChatGPT and, for instance, also DALL-E, the tool that outputs AI-generated art. But we also witnessed the advent of surgical robots, for instance, that take over ever more tasks of human doctors. Agricultural robots calculating the best conditions for crops and how to kill weeds, and doing that as well. The next Rembrandt, which you see here on my screen, which has entirely painted by an AI algorithm, and Beethoven's 10th Symphony, which he never wrote, but which actually sounds quite credible, albeit being entirely AI generated. From a legal and regulatory perspective, AI technology is relevant, as their deployment may have legal consequences. That can, of course, be the case when, for instance, machine learning, the input requires the analysis, processing of large amounts of data, or when activities of a deployed system are logged in a database output. This can constitute personal data processing, as regulated by, in the European Union, the General Data Protection Regulation. Or when the input and training of large language models, LLMs, requires the reproduction of works that are copyright protected, or when trade secrets are being processed. And when a medical diagnosis is missed by an AI algorithm, or when an AI algorithm is deployed in a vehicle but nonetheless causes a crash, this could lead to damage which must be compensated, of course. Well, some of that is taken account of by the AI Act and some of that isn't. Regulating AI stands high on regulatory agendas, which is also illustrated by the next speakers. In Europe, we have finally the AI Act, which has been proposed firstly in 2021 by the European Commission. Its final texts are expected to be published this month in the official journal or beginning of next. The first tier on unacceptable AI practices will enter into force later this year. Amongst many other things, the Union legislator aims to promote AI innovation in view of the economic, environmental and societal advantages that could be expected from the technology. At the same time, however, the European Commission acknowledges that there are also downsides of AI. Risks, negative consequences for individuals, for human rights, for society as a whole. The regulator strives to find a balance between, on the one hand, stimulating innovation, and on the other hand, the introduction of lawful, trustworthy, and safe AI, which respect the fundamental rights of European citizens, on the other hand. Well, first, I'll sketch some of the most important principles that are to be regulated, and then I'll illustrate the role that lower regulation may play therein, because there's a very, very important role for lower and self-regulation under the AI Act. Well, let's look into 4 different categories of AI under the regulation. First, there is unacceptable AI. There also is AI with high risks, which is heavily regulated. Unacceptable AI may never be introduced. High risk AI is heavily regulated. General purpose AI and limited risks AI are a bit less regulated. What is unacceptable? AI qualifying as holding unacceptable risks will be forbidden. And this includes, for instance, cognitive behavioral manipulation mechanisms, which deploy subliminal techniques beyond a person's consciousness in order to materially distort a person's behavior in such a manner that it's likely to cause or is causing physical or psychological harm. Also forbidden, which may never be introduced in society, are social scoring mechanisms to be used by public authorities, or real-time biometric identification systems to be used in publicly accessible spaces, unless in very, very specific circumstances. High-risk AI, that's the second category, may negatively affect fundamental rights protection of citizens or their safety. Examples include systems to which the EU product safety rules apply, such as cars, aviation technology, toys, medical devices, and elevators, surprisingly. Also high risk will be AI systems allowing for biometrical identification, AI systems connected to critical infrastructure, or AI used in education, AI related to employment, worker management, and access to self-employment, essential services, law enforcement, migration, asylum, border control, assistance to legal interpretation and application of law. So the robo judge will be, I think, categorized as a high-risk AI. Then we have Gen AI, general purpose AI, such as DALL-E and ChatGPT and other LLMs. I'll say a bit more about it later, but all other systems are low-risk AI, limited risk. Then looking into roles and responsibilities. The AI Act defines many roles for those to be distinguished in the development and deployment of a chain of AI. Most importantly, the Act separates between providers and deployers of AI. Providers are those who develop an AI system with a view to placing it on the market or to put it into service under their own name or trademark, whether free or paid. Deployers are those entities who use an AI system under their own authority, excluding non-professional personal use. High-risk AI systems are most heavily regulated. High-risk AI must be administered in a continuous, iterative basis in a risk management and mitigation system. There are, for instance, data quality criteria for high-risk AI. It's regulated that training, validation, and testing data sets shall be subject to appropriate data governance and management practices. And these must be relevant, representative, free of errors, and complete. The logging capabilities, which also need to be embedded in high-risk AI, shall ensure a level of traceability of the AI system's functioning throughout its life cycle, which must be appropriate to intended purposes of the systems. Also, it's required that these systems will be designed in such a way that their operation is sufficiently transparent in order to enable users to interpret the system's output and to use it appropriately. Furthermore, high-risk systems ought to be effectively overseen by natural persons during their use. And an appropriate level of accuracy, robustness, and cybersecurity must be ensured at all times. Well, that's not enough yet, because although the AI Act does at some point provide minimum criteria, these norms, the vague and open and many norms, are left open to be filled in by regulatees themselves or through private regulation schemes. I'll return to that later. Besides high-risk AI, there also is general purpose AI. And Gen AI is divided in two categories in turn. Normal Gen AI should never be deployed unnoticed. This means that users or deployers of Gen AI models must at all times be transparent regarding their use of the technology. AI-generated output must always be detectable and disclosed as such. When Gen AI poses a systemic risk for citizens, the rules are stricter. There is a systemic risk when there is a significant impact on the internal market due to the reach of the model and with actual or foreseeable negative results on public health, safety, public security, fundamental rights, or the society as a whole, which can be propagated at scale across the whole value chain. These are the text of the legislator, I can't help it. But the European Commission will publish a list holding the most eminent forms of systemic risk, Gen AI. Systemic risk must be presumed when the cumulative amount of computation power used for its training, measured in floating point operations, flops, is greater than 10 to the power of 25 for those who are interested in numbers. Rules for Gen AI models with a systemic risk are, of course, stricter than for normal Gen AI. Systemic risk AI needs, for instance, to be accompanied with sufficient documentation, and functioning needs to be monitored as well and evaluated. Risk must be identified and mitigated, and incidents must be reported to the authorities. Low risk is way less stringently regulated. Rules mainly see to transparency. It's held that providers must ensure that natural persons who interact with the system are always informed that it's a system rather than a human with whom they're communicating. Consumers must be informed of the use of emotion recognition systems or biometric categorization systems. When consumers are to be confronted with deep fake technology, they must also be informed thereof. Then some words on co-regulation. As the union legislator observed, the principle-based open norms should contribute to a robust and flexible legal framework, which can adapt to the technology. The legislator sees to the creation of standards or other technical specifications developed in accordance with general engineering or scientific knowledge at the discretion of the provider of an AI system. In that, the legislator aims to provide flexibility to choose their own way to comply with the requirements by innovators. High-risk systems which conform to harmonized standards, which are to be developed at this point, shall be presumed to be in conformity with the requirements I just read out from Chapter 2, to the extent that the standards cover those requirements, of course. And where harmonized standards do not exist yet or are deemed insufficient, the European Commission may adopt implementing acts with common specifications in respect of the requirements of this Chapter 2. And these harmonized standards will have to be newly drafted. The processes have begun already, but the outcomes are not yet clear by CEN and CENELEC, the European standardization entities for electrotechnical engineering. These organizations are represented in the participants process, mainly consist of industry stakeholders, and it's observed that civil society is not overly represented there. But we'll see what comes out. We have a lot to expect from the standardization processes, as these will fill in those norms. Norms are strictly enforceable through public and civil means. The AI Act aims at a strict enforcement mechanism, and it seems to be inspired by the GDPR, the General Data Protection Regulation. Member state authorities can fine seriously. For instance, when Article 5 regarding forbidden unacceptable AI practices, when that's neglected, or Article 10 regarding data quality and data governance, these they can be fined with a penalty up to 35 million euros, or 7% of the annual worldwide turnover, whichever amount is higher. And non-compliance with the other provisions of the AI Act can be subject to a fine of 15 million, or 3% of the annual worldwide turnover. Lying to a notified body or a national competent authority can result in 7.5 million euros penalty, or 1% of your annual worldwide turnover. Given the fact that innovators will likely have to invest heavily to comply with these norms, while the norms are not clear yet, and the fines are potentially astronomous, this can lead to the assumption that the framework is going to be rather strict. And that's not all, because there's also civil liability. There's not a civil liability mechanism enshrined in the AI Act, which is the case for the GDPR. However, there are proposed changes have been proposed to the Product Liability Directive by the European Commission, the PPLD, and also they've been drafting an entirely new directive on AI liability, the AILD, the AI Liability Directive. In the PPLD on product liability, a software will be brought in scope explicitly, and virtually all actors in the supply chain of AI systems will become subject to risk liability. This implicates that consumers who suffer damage from defective AI can claim compensation. Products under the PPLD are defective when a product does not provide the safety which the public at large is entitled to expect, taking all relevant circumstances into account. These include the effect on the product of any ability to learn after the development, or the manufacturer's ability to control the product after it's been marketed, for instance, through upgrades or updates, as well as product safety requirements, including those from the AI Act and specific cybersecurity requirements. Still, it will be up to the victim to prove defectiveness, to prove damage, and to prove the causal relationship between the two. This implicates that the victim needs access to meaningful information regarding the functioning or the non-functioning of an AI product in order to successfully argue that it might have been defective and causing damage. That's quite a high burden of proof, and in order to alleviate this burden, the union regulator obligates users and providers of AI systems to disclose necessary information to a victim who has a plausible claim under the PPLD. Should a defendant refuse a court order to disclose certain information, this may lead to the presumption that the respective product was defective. And this defectiveness should also be presumed when a claimant can establish that the product does not comply with mandatory safety requirements, such as stemming from the AI Act, or when there was an obvious malfunctioning of the product during its normal use under ordinary circumstances. And further procedural aids for victims are stipulated regarding the causal link between defectiveness and damage when the defect has been established and when the damage is typically consistent therewith. Judges may even presume both causality and effectiveness when victims face excessive difficulties due to technical or scientific complexity, be it that the victim should still demonstrate on the basis of sufficiently relevant evidence that the product contributed to the damage and it was likely defective, or that the defectiveness is a likely cause of the damage. Where producers can traditionally fend off a liability claim with defenses based on the argument that defect came into existence after putting it in the market, or that it could not be discovered at the time of the marketing, these can no longer be upheld when the producer still exercises control, or should exercise control over the AI-endowed product, or failed to provide updates or upgrades that's necessary to maintain its safety. Well, the PPLD also sets the bar a bit higher for innovators. This may well be justified, as it will become easier, fairer for victims to successfully claim damages. And besides this product liability rules, there's also the AI liability directive, which does not do much actually on a material basis, but holds also some procedural rules which are comparable to those of the product liability directive. It's a very hard read. It's very well illegible actually, and it consists of many complex formulations. It's a puzzling exercise, but I think it does the following. Article 3 imposes procedural obligations on the providers and deployers of AI, as they must preserve and disclose evidence at their disposal in cases where high-risk AI are suspected to have or have caused damage. Again, here one should question the deployer to hand over evidence, and when they deny, you can go to a court, and when the court says, well, here, publish the evidence, and then that must be done. And a defendant's non-compliance with the relevant duty of care shall lead to a presumption of non-compliance as well. Victims face an uphill battle to prove a norm violation and causality in AI-related liability claims, obviously, and they're not helped very much by this new AI liability directive. We'll see what happens. It's still in the regulatory process, but these are the steps that are being taken by the European legislator. But of course, this is not all. We still have the GDPR. There also is the European Fundamental Rights Charter. We have IP rules. We have privacy rules. We have labor law. We have many laws and regulations that all apply to the development and deployment of artificial intelligence. Well, how to continue from here? I think it will be good to keep in touch in sharing visions on which rules apply to which forms of technology. And I think it's good to observe now already that the AI Act, the Product Liability Directive, and the AILD present a whole new set of rules, which are not to be overlooked by developers and deployers of AI who like to be active in the European markets. The AI Act, in combination with the to-be co-regulated norms and standards, may prove a source of compliance obligations, with significant implications for both providers and users. Significant, as not only the compliance bars will be set rather strict, also the enforcement mechanisms will imply stringency. Fines are very, very high, even when compared to the GDPR. And albeit 82 GDPR-like regime misses, the PPLD and the AILD must be accounted for. All in all, I would say that the AI Act rules are aimed to effectively improve the rights of citizens, and we're finding ourselves on the brink of a new and true lawyer's paradise. Thank you very much for your attention. And I think I'll hand over the floor back to Richard now.
Yeah, it's back me. We go further directly. Thank you so much first, Roland, for that excellent presentation. And we continue directly with John.
Thank you, Richard. Thank you, Roland. Good afternoon, everyone. Or good morning, maybe, in America as well. Very happy to follow on from Roland. I'm a technology IT lawyer based in the UK. So for the past 25 years plus, I mean, we've been advising IT service, software companies, and advising on IP rights and increasingly GDPR. So no surprise that we're spending a lot of our time these days acting for clients who used to be called software companies, who are now AI or data analytics experts. The UK is taking a very different approach to the EU. Sorry, I lost the slides there for a second. Let's try again.
We can see it, John.
Yes, I'm just trying to get to the next slide, but it's not.
Maybe just click in it.
Ah.
Yeah, there you go.
Thank you. Yeah, next slide. Yes, we've taken a very different approach in the UK, and I thought it was useful to set off a quick overview at the outset. A quick bit of history on this. Last March 23, the government issued a white paper in relation to AI regulation. It opened it up to consultation amongst industry, academia, and various other sectors. And this February, it was largely endorsed by the government again, not surprisingly, endorsing its own sort of suggestions. We, a bit like the EU, are stating to try to follow a pro-innovation approach, but the UK so far has taken a different approach or different stance in that the government is saying it's too early to try to decide on black and white new rules coming in because the technology is expanding so quickly and in such an unexpected way. So the pro-innovation approach that we are taking is being led by regulation. And the idea is that we have opted for a cross-sector outcome-based approach whereby up to 90 regulators who regulate different areas of public and industry life will be looking at AI risks and AI development in their particular sectors and issuing guidance, guidelines and principles. They have to implement 5 core principles, which I'll come on to in the next slide. It's pretty clear, though, that even though the government has not gone down the EU route of legislation in hard and fast rules, targeted legislation will be needed at some point in the future, possibly sooner rather than later if we change governments, which looks very likely. The government's approach at the moment is to say that we'll only need legislation once we know what the risks are and when it's clear that the existing rules and regulations have gaps that need to be addressed. So it's fairly clear, even at this early stage, that businesses, organisations generally must prepare for increased AI regulatory activity in the coming months and years and be prepared to take that on board. Because in the UK, we're taking a regulatory approach in terms of guidance and principles rather than laws, there is, of course, the potential for divergence with other jurisdictions, in particular the EU. At the heart of the UK's approach are 5 core principles, which are set out here. Although it's a different approach to the EU, underlying the EU AI Act, most of these principles you can, I think, readily identify. The key ones are safety, security, robustness, transparency and sustainability, fairness, accountability and governance, and contestability and redress. Because bearing in mind the underlying risks in relation to AI and the fact that it's a complex area and unpredictable, those principles are, I think, not surprising. What may be more challenging is how they're actually interpreted in practice. particularly where in the UK it's been estimated we've got actually up to about 90 regulators, some much bigger and more powerful and rich in resources than the others, but trying to coordinate and make sure that there is a common and consistent approach to interpreting these principles is one of the key concerns at the moment. Obviously, in relation to a principle such as safety, security, robustness, there are already good cybersecurity standards, existing GDPR data protection laws that people can fall back on. In other areas, such as fairness, although that is an indirect sort of reference to unconscious bias and the problems of having biased data going into systems and leading to biased outcomes, quite how fairness will be, fairness is a very subjective term, how that will be interpreted in, say, the competition and marketing authorities remit compared to the finance conduct authority is open to question. So there are some issues here over consistency of approach. In relation to who carries out the implementation, as I say, the government effectively has delegated that to regulators, and there are up to 90 of them. Because of the concerns in relation to consistency of approach and a common approach, they have set up some new bodies to help with this. DSIT, sorry, it's a bit of jargon, that's abbreviation for the Department for Science, Innovation and Technology. DSIT were the department behind the actual initial white paper. They have set up a new central function whose main role is to try to look at, identify AI risks across the board and suggest ways of managing those. Also, the central function has got an important role in trying to get coordination between the regulators themselves to take a consistent approach in the way they interpret and implement the core principles. The AI and Digital Hub is also a new creation of 4 of the biggest regulators, that is a Competition and Markets Authority, a Finance Conduct Authority, the Information Commissioner's Office, and also Ofcom, dealing with communications and TV. And again, those 4 bodies have clubbed together. The idea of the AI and Digital Hub is it will provide sort of proactive advice and also provide sandboxes so that pilot testing of systems can go on before they're deployed commercially. So hopefully risks in relation to outputs, how the systems work, can actually be addressed before they're launched and before they cause problems. As I say, the current concerns are certainly, the key concerns are an inconsistent approach by regulators, given there's so many of them in different fields, leading to uncertainty for businesses because you may not be sure, AI developers who have products that are capable of use in various sectors may not know exactly what rules, what guidelines they need to comply with. Another practical one, something I haven't mentioned on the slide, but also is the issue of resources. Some of the regulators are very big and are quite rich in resources. Others are quite small, quite poor. And at the moment, some of the smaller regulators have complained to the government saying, you've given us this task of implementing AI on your behalf effectively in our sector, but we don't have the manpower resources to actually do that. So again, I think there's quite a possibility that some of the bigger regulators, like the ones behind the AI and Digital Hub, will become super regulators and will often be leading the way that other regulators follow. That's speculation, but it may well happen. Probably should have started with this slide earlier on, actually. What is AI under the UK framework? There is no single formal definition, but you'll see the references here to adaptivity and autonomy, and the references to those, it's very similar to what Roland was saying in relation to the EU Act. So not surprisingly, whilst we don't have a single simple definition, the framework emphasizes the 2 key characteristics in relation to systems that can see patterns and make decisions that aren't envisaged by their human creators, and also the capacity to take actions and decisions again without human oversight. The aim, the government's hope, is that this allows the UK to be flexible and be sort of flexible and sympathetic to the relevant sector that it's regulating. At the same time, of course, pessimists and that cynics might say is going to risk different interpretations, leading to general uncertainty and confusion across the board. Some quick factual things. 2024 has certainly been a busy year. To some extent, in the UK, we've probably been at government level catching up with maybe the rest of the EU and Europe. February 24, I mentioned the government confirmed the white paper approach. Already by the end of April, the regulators had to publish their initial approach to implementing the AI framework. And I must say, it doesn't make particularly educative reading. The initial approach has been fairly brief and really saying not much more in most cases, other than that AI is a very complex area. We're still looking into the key risks for our particular sector, and we'll come back with guidance in due course. The government has also set up some initial coordinating steps between itself and regulators, and between the regulators too. That's been happening in the first part of this year. By the end of 2024, the government has set itself the target of having updated guidance on high-risk systems, and by April 25, UK regulators are required to publish more detailed, definitive guidance on AI in their sector. I would just reiterate, of course, that it's very much a sector approach at the moment in the UK. New bodies, these are a couple of bodies I've mentioned in earlier slides, so no reason really to go on to them, but there are some links there for those interested afterwards to actually look up how these bodies actually operate. High risk systems. Although we don't have any specific black and white rules in relation to high risk systems that the EU does, and Roland's obviously explained there very clearly, but in relation to high risk systems, first of all, the government has got a commitment to giving more detailed guidance by the end of the year. There are no new rules for now, but in the new white paper that was endorsed in February, we have identified 3 types of higher risk AI systems. That's the highly capable general purpose AI, highly capable but with a narrow focus, and also AI agents. And any new rules and guidance is going to be applying to those as we go along. There is a general anticipation that some new legislation sooner or later will be needed for high-risk systems. And as I say, even although it's early days, the CMA in their initial AI guidance has given an update, and they actually did quite a useful introduction as to where they thought there might be risks in relation to high-risk systems, but from a competition point of view, and they were particularly worried about some of the leading tech giants having so much resources to invest into the high-risk systems that they would have a trickle-down effect or dominate downstream systems into the future. And so they're already talking about trying to have controls on anti-competitive behavior by the biggest tech giants out there in relation to high-risk systems. Want to move on to some practical points that businesses, but I suppose by businesses you can really understand, organizations generally will need to bear in mind. Given the underlying thrust of those 5 core principles, which are very similar to the aims of the EU Act, it's clear that all businesses, whether you're a provider or a deployer of AI systems, you need to ensure that senior management takes the governance seriously. From now on, organizations will need to be checking more regularly with the relevant regulator or regulators that affect their day-to-day business, and also the AI systems that they employ in providing their own services. Obviously, for developers, for providers of systems, aiming for compliance by design, a bit like the GDPR, GDPR compliance by design will be increasingly important, and ensuring that those 5 core principles are at the heart of both development of AI and its use. A good practical starting point for most businesses, organizations, is to establish an AI risk register. In other words, what are the risky areas in your business or development of systems that you're trying to supply in relation to AI? And as far as possible, identify those risks early and obviously have a corresponding system for managing those risks. Also, as guidance evolves over time, existing company policies will need to be amended in line with that. For example, privacy policies, IT use policies. On the developers, on the provider side in particular, it's going to be very important to identify AI risks. Also, it's going to be very important to show that your systems have been developed with a reasonable skill and care, because most AI systems under English law are going to be seen as software and probably seen as services rather than goods. So it's important to show that they've been developed or used with reasonable skill and care. And the bullet points on the slide here, if organizations are following those, they have a much better chance of showing that they've taken all reasonable steps in the light of, the relevant technical knowledge of the industry at today's date. So ensuring safety and security of data on which systems are developed. The transparency, as Roland mentioned, very important. If things go wrong, it's possible to show how the system is working, what the main rationale underlying the system's output are. And if you're unable to do that, a provider is much more likely to have some form of legal liability. Also important to show that there is a clear structure and responsibilities for the AI system teams developing the system, and also for keeping humans in the loop in relation to AI system outputs. Finally, in relation to, I think, key action points for businesses who are using AI systems in their services, again, important to try to check with pre-contract due diligence that AI systems you're using have been trained on suitable and appropriate data. They've been built and managed properly by the developer under control. Have they been validated and checked by suitable testing before they let loose on you and possibly end users who could be individuals? Is it clear that any decisions made that have an effect on individuals, how those decisions have been arrived at? Again, another aspect of transparency. And as far as possible, obviously, to check that obviously the output and these systems themselves will be compliant with the regulations and the 5 core key principles. On a practical sort of contractual level as well, it means there'll be even more need for suitable warranties in relation to areas such as training data used, no unlawful outputs arising from use of a particular AI system that you're using. And in some cases, you may actually want more than a warranty, but an actual full indemnity protecting you from IP infringements, which arise from use of the AI system, and personal data breaches. Final comments before I hand over to Rob and the US. Clearly, in the UK and elsewhere, regulation is really just starting. And if anything, I think we're slightly behind the curve. So in a way, we're catching up. Consistency, the fear about having a large number of different regulators with varying degrees of resources. There is a big worry that consistency just won't be there, and that's going to be a challenge for us. At the moment, out of interest, there is no actual strict legal duty on the regulators to enforce these 5 principles. That probably will come in sometime soon by way of some statutory duty. But at the moment, just to note, there is no actual law as such requiring regulators to do that, but although they are doing that in practice. And finally, a little bit of speculative thinking on my part. As most of you probably know, we've got general elections in the UK next week. It's almost certain there'll be a new government under Labour, and certainly up until the election, whilst AI has not been top of the election discussion, Labour have made it clear they don't think the Conservative government have gone about AI regulation the right way. They think the government should have intervened more by way of legislation. So there's every chance that there will be legislation to fill in the gaps of the regulations, or even replacing it sooner rather than later. And finally, lots of speculation that Labour wants to get closer to the EU after Brexit and everything. So in a way, whilst we've got our 5 core principles and the UK regulatory framework, in reality, do we already have a de facto standard? And it will be the EU AI Act, maybe following on the same way that we've left Brexit, but so far we haven't changed GDPR at all. That's speculation on my part, but under a new Labour government, that's much more likely than it would have been if the Conservatives stay in power. And now, thank you. Thanks for your attention, and I'll hand straight over to Rob and the US.
Good day. Thank you. I'm Rob DeBrouwer from Pryor Cashman in New York City. I am the co-chair of the Digital Media Practice Group here. My practice lies principally at the intersection of technology, intellectual property, media, entertainment, and music. Just looking to share my screen. There we go. Okay, can you all see my screen now? This is okay, good. Because I cannot see it on the screen. So in any event, I just wanted to describe a little bit about me and my background and why artificial intelligence is particularly important to me. I was a former relational database programmer at Unisys Corporation way back in the day. And before that, at university, I took a course on engineering, and my thesis at the time, as I'm a type 1 diabetic, and you can see here I have this insulin pump that I wear, was the feasibility of closed loop artificial insulin delivery systems. And we're just about there right now. And what affords that is machine learning and artificial intelligence. I have a continuous glucose monitor that interacts with my pump, that delivers insulin to me based upon it's learning my behaviors and things of that sort. And so obviously regulation is important. I want to make sure this thing doesn't kill me. But in the United States, what makes us a little bit different than certainly the EU and in large part the UK is that we're principally a common law jurisdiction. So AI, the approach to AI in the United States has been very much decentralized at this point. It's largely vertical by industry, sector, and discipline, not horizontal, like in the manner that Roland explained. And I can give you a sort of perfect example of how, you know, legislation plays out in the United States. There was a recent Supreme Court case in 2019 called Fourth Estate dealing with copyright registration. I'll get to the importance of that in a little later. But in the Copyright Act, it says, you know, you can't bring a civil action until your work is registered. So registration of copyright in the United States is very, very important. But in different jurisdictions, registration meant different things. So in the Second Circuit in New York, if you applied for a copyright and you deposited the deposit copy and you paid the fee, you could bring an action. In other states, you had to wait until the Copyright Office actually took action. In any event, you know, this is kind of the hodgepodge way in which laws kind of work themselves through the system in the United States. It's through case law and precedent and interpretation. So in the United States, we still have no general federal data privacy legislation, and certainly at this point, no federal AI legislation. But in 2002, October, the White House, which is relatively early, I mean, it was before the onslaught of generative AI and ChatGPT, so it was a little bit forward thinking. The White House Office of Science and Technology Policy, you know, published this white paper, but it's merely a non-binding blueprint for the responsible use of AI. And it is horizontal and it is fairly broad and it's not sector specific, but it describes protections to be applied to automated systems that have the potential to meaningfully impact individuals or communities' exercise of civil rights, whether that be, you know, the right to speech or the free voting or freedom from discrimination, equal opportunities, access to housing, education, credit, employment, et cetera, or access to critical resources like healthcare, vis-a-vis, for example, my insulin pump. It does not supersede or modify existing law. So in large part, for example, there's a ton of regulation and legislation that, you know, is taken care of through the federal drug, at the FDA, the Federal Drug Administration, that deals with, you know, things like insulin pumps. So this blueprint is non-binding, doesn't supersede or modify any existing law. There are exclusions to enforcement dealing with law enforcement and national security. So, you know, all of these principles don't apply in every circumstance, but the, you know, effectively the reason for the white paper and then these, you know, principles that I'll get to in a second, the 5 principles similar to the EU and the UK, is really to balance the benefit of technology, tech advancement against, you know, whatever harm that AI can have to civil rights and democratic values. And so under this blueprint, the definition of AI or an automated system is a system, software, or process that uses computation that makes or aids decisions, can inform policy, collect data, or otherwise interacts with individuals and communities, and you know, can be derived from machine learning, et cetera. But the interesting part of this is that it's really effectively high-risk AI that is being addressed in this framework. It's automated systems that are considered in scope are only those that have the potential to meaningfully impact rights, opportunities, or access. And similar to the EU and the UK, this framework, again, which is non-binding, is applicable to design, development, and deployment of AI. And similar to the EU and the UK, and I'll sort of roll through these pretty quickly because they are so similar, are safe and effective systems. So protection from unsafe or ineffective systems. You need system testing, risk identification and mitigation, and continuous monitoring. You want to avoid algorithmic discrimination, so that, you know, any protected categories like race, color, ethnicity, sex, religion, age, etc., there's no prejudice built into the systems. And then data privacy, protection from abusive data practices and allowing citizens to have agency over how their data is used. And a significant part of US data privacy law, even though it's governed by various state legislation at this time, is that it conform with reasonable expectations. So, you know, there's case law that you may have heard about, or cases where, you know, someone is sitting in a tree and taking a photograph of a celebrity in their home from, you know, hundreds of yards away. You know, that person has a reasonable expectation of privacy, and that is a violation of their right if they did have that. You know, again, these blueprints and these principles are really merely aspirational. But in the data privacy realm, you know, data minimization is called out specifically, and that is, you know, in certain respects antagonistic to large language model training, which needs as much information as possible. Notice and explanation are among the principles, so knowledge of how it's used and its impact. And then very importantly, human alternatives and consideration and fallback. So the ability to opt out and to access humans, particularly if the AI is intended to be used in sensitive domains like criminal justice or health, for example. And as I indicated, you know, the legislation that has been enacted thus far has been left to the states, and there are only 2 states that have enacted, you know, what I would call comprehensive legislation pointed at AI, and that's Utah, which really focuses on generative AI. And under the Utah law, you know, I think the thing that's most important, and again, we don't have a lot of time here, is that it requires disclosure when an individual interacts with generative AI in a regulated occupation. But it does create this oversight, the Artificial Intelligence Learning Laboratory program to assess technology's risks and policies, and it does enable mitigation of regulatory impacts during pilot testing, and the Office of AI. Interestingly, the other state that has a comprehensive AI law that's been passed, and it's sort of more similar to the EU, is Colorado. And I've pasted in my slides here that a letter from the governor of Colorado, Jared Polis, when he signed the legislation. And I'll just read some part of it, because this is the most comprehensive legislation that we have thus far in the United States. But he writes, "Today, with reservation, I signed Senate Bill 24205 concerning consumer protections and interactions with artificial intelligence systems. This is an important conversation to have, and in signing this bill, I hope that it furthers the conversation, especially at the national level." So he's imploring the federal government to create a national law. And he talks about the risks, and he says, you know, it imposes new regulations on developers and deployers of high-risk AI. The bill defines as any machine-based system that infers from data inputs how to generate outputs, and it goes into effect in 2026. And effectively, he says, I'm skipping ahead, that I appreciate the goals of the sponsors to begin an important and overdue conversation to protect consumers from misunderstood and even nefarious practices, but let's change this law before it gets enacted in 2026. So I think it's, you know, an interesting development, and it's led in with a statement, you know, that's very, very suspect of the law in itself. And the fundamental aspects of the law for those using high risk AI are these risk management policies, impact assessments, and notice to consumers. And that's very bureaucratic, very much red tape, which is in keeping with the EU, for example, and GDPR, but very dissimilar from practices in the United States. And so those who are involved in, the business aspect of creating and deploying AI are very much concerned that these regulations could chill technological development. So again, the concerns are undermining the local AI startups and that it's too burdensome and threatens and chills free speech. So some of the other sort of more vertical AI laws that were passed in the United States relate to, copyright. And I mentioned earlier the importance of copyright and registration because you can't enforce your copyright unless it's registered in the United States, which is different from most everywhere else in the world. And so the Copyright Office has taken guidance, and the courts have interpreted that guidance as to whether any machine learning or AI system participation in the creation of a copyright work invalidates the registration. And there's been a few cases about that. One of them is Zarya of the Dawn, the comic book. And when the application was filed at the Copyright Office, they didn't disclose that the images were created by AI. And so upon finding out about this, the Copyright Office rejected the application and said that the comic is not susceptible to copyright protection, and then you can't protect your rights in and to that comic. There was further litigation at the Copyright Office, administrative litigation, and it was determined that limited protection would be given to the arrangement of the text and the images, but not the images themselves. And then the second thing where I'm showing you the pictures here, Sirius, the Van Gogh image, the photographer took the photograph that you see all the way on the left and asked Midjourney to create an amalgamation of that photograph and Van Gogh's Starry Night, and created the output, which is the third photograph there. And the Copyright Office rejected the application and found that no copyright pertains to that, and therefore you can't enforce, protect, or do anything with respect to that work, which was not deemed sufficiently original in the hands of human beings. Other vertical AI laws that are related to industry, and obviously copyright, media, and entertainment are huge industries in the United States, which is why I brought up the copyright issue in particular, is a labor and employment law in New York that was effective January of last year, prohibits employers and employment agencies from using automated employment decision tools unless they ensure a bias audit was done. So it's to protect from discrimination and hiring practices in New York, which is very important, as New York obviously is a significant hub for commerce and business on a global basis. And in particular, employers and employment agencies must publish a summary of the results of their most recent bias audit and the distribution date of the tool that was used, the AI tool. And the bias audit must be conducted annually, and then penalties of up to $1,500 a day for compliance. And then another vertical, obviously, which is very, very important, and legislation that was passed in the United States pertaining to the entertainment and celebrity industry, among others. And again, this is a very short presentation, so I can only get into a few of the some of the legislation and the regulations that have been passed, and not all of it, but one is the Ecovis Act, and it's a funny acronym, the Ensuring Likeness, Voice, and Image Security Act, that was signed earlier this year, a couple months ago, in Tennessee, which takes effect next week. And for the first time, voice was protected and it was renamed from the Personal Rights Protection Act of 1984, and it governs, voice, name, photograph, and likeness, and it provides civil liability, sort of three bases for that. And that's the knowing use of the name, photo, voice, likeness for purposes of advertising and fundraising, solicitation, et cetera, without consent. And that's sort of very similar to most data privacy. It really is, it's a privacy law, but we call it misappropriation. It's one of the 4 privacy torts in the United States, or right of publicity. And most statutes like New York Section 5051 of the Civil Rights Law that govern this is very similar. It's about misappropriating those things for purposes of advertising or trade. But secondly, there's publishing, performing, distributing, transmitting, and making available a person's voice or likeness with knowledge it was not authorized. So that's a great expansion of most privacy publicity laws, because it doesn't necessarily have to be in the context of advertising or trade that you're using it. It's saying even in a context where it's not for purposes of advertising or trade, where it could make someone look bad, or on social media where you're not actually selling or advertising a product, this limits that use. And more importantly, with respect to AI systems and developers and deployers, distributing, transmitting, or otherwise making available an algorithm, software, tool, or other technology, the AI itself, the primary purpose or function of which is the production of an individual's photograph, voice, or likeness without authorization. So liability can inure to the developer and provider. And so it's a short presentation. That's all we have. Elvis has left the building. Thank you very much.
Is there any questions? We have a couple of minutes for questions, unfortunately not that long due to other arrangements, but I saw one question going in John's direction, now going in Roland's direction. This from John, and he wants to ask Roland if he knows when the II liability directive will be a law.
Yes, I'm not sure if I missed it, Roland, but yeah, when it was coming in, people I thought might be interested, I was.
Thank you very much for this question, John. Not anytime soon is the answer. We've also just had elections recently in the European Union, and I think it will be on the agenda somewhere in the coming year, but it's still early stages of lawmaking. So not in the coming year or two, I expect.
Thank you.
I'll keep you updated.
Thank you.
Any further questions also from the audience? I know it's a lot of information, a lot of new material that we all heard.
I see Julia Dimitrieva having a question.
Yes, hello. My name is Julia Dmitrieva, as you said, from Ecovis, Bondar in Bonn and Kiev. First of all, thank you all for great presentations. I wanted to ask mainly John and Robert about the extraterritorial impact of the EU AI Act. How do you see it? Because you obviously spoke a lot about the differences, especially in UK-EU relations and probable changes in the legislation that might follow. But given the scope of the AI Act, it's already impacting third countries and third country businesses. So how is your practical view on this one? Thank you.
Thank you for the question. Well, because the EU Act has extraterritorial effect, it is already affecting UK companies, because obviously if for any providers of systems from the UK that are used in the EU, or I think have an effect on EU citizens effectively, we're caught by the Act. So you're probably alluding to my last comment on the side about the fact that in the UK, of course, we're stressing we have regulations, no new law as such. But in practice, we've left the EU, but we left the EU past all the laws. And to be honest, in the years since we've left, we haven't made many changes to the laws we acquired under the EU. GDPR, there may be some minor changes around the edges, but the broad laws are going to stay the same. And so it may well be when we come to implement things ourselves, I wonder whether we'll actually sort of recognise the EU AI Act as the easiest way to follow, because the underlying aims, principles are the same. The EU Act and our principles are based on, again, international, if not treaties, international collaborations. Just recently, the Seoul AI Summit was talking about commitments between the leading industrial nations having a shared approach to high-risk systems. So in reality, although the wording looks different, the aims of our regulations are the same as the EU AI, and I can easily foresee in a few years' time us implementing something very similar, or actually adopting it in its entirety is the easiest way to go.
And I anticipate that we'll likely deal with it in the same way that we do with GDPR. To the extent that it involves EU residents, I think we'll need to advise our clients to not only follow the laws of the United States, but the sort of heightened laws in the EU, and work with folks like Roland in the EU, which we do with respect to data privacy matters, where our clients are principally targeting EU residents to make sure that we have an approach that not only complies with US law, but the heightened scrutiny of the EU as well.
And of course, as an English lawyer, then talking about GDPR, but I guess the principle's analogous, Rob. I was always amused by the fact that even between two US entities, sometimes in terms of good practice, they'll refer to the EU GDPR and say, basically, we'll comply with this as a matter of contractual law, as evidence of good practice. So I can see that may happen for AI as well, going down the line.
Indeed, I often advise. I'm sorry. I was just going to say, I advise clients, if you want to be good corporate citizens, you might want to abide the highest standard.
Sure. Yeah, I think we have another question from Julia. She raised her hand. Is that correct, Julia?
No, that was me, actually. It's okay. I already asked my question. Thank you.
I do see a question from Geert Koster, Richard, in the chat.
Yeah, we have another question in the chat. That's great. Can anything be said about the capacity of enforcement of authorities to effectively implement and monitor compliance?
From a European perspective, we don't know which are going to be the competent authorities as of yet. In the Netherlands, we have the Dutch Data Protection Authority, who thinks they're going to be the authority, and they're aligning and increasing their forces in order to be able to enforce the AI Act as well. But as we have already seen earlier with the introduction and implementation of the GDPR, and my estimate will be that they will be understaffed for the first 4 to 5 years. I don't know how what was it like in Germany, Richard? Do you have many competent authorities? I take, but they are rather effective, aren't they?
Well, to be honest, I don't hear much about enforcement yet,
no.
Right? But you hear a little bit about it. But I think the big wave is still coming, also in Germany.
Yeah. And I think that the same will hold true for Colorado and Utah, Rob. Yeah. So
we have an election. We have an election this year as well, and who knows what the heck is going to happen after that. That map that I put up at the very beginning is a representative of some of the greatest strength of America and the greatest weakness. So I'm not sure that we'll be able to get legislators to agree on anything or to pass anything.
That's a very diplomatic answer, Rob. I don't know, John. What do you think for the UK?
From the UK perspective, in terms of enforcement, I mean, our enforcement authorities in relation to the AI framework are the relevant regulators within their sector. They have, well, they are, should we say, general principles, I suppose, which are being enforced. Enforcement action, I don't think there's been any yet, but it's likely to be in the guise of fines or sort of reprimands. But don't forget, some activity by AI system developers or users may also fall foul of traditional existing laws, because that's obviously what we're basing our current approach on, a mixture of existing laws and new guidance. So that there may well be civil actions possible by individual parties under contract law, data protection law, other laws. And failing that, it's going to be very much up to the regulators to enforce. And that's going to be more by, I think, fines than anything else. And I think because we've got a plethora of regulators, they don't all have the same powers of enforcement generally in relation to their sectors. That the ability to fine is usually the one that they use, is the best deterrent, we say, to misbehavior within their sectors. But too early to conclude, I think, because we're still really just starting out on the journey here.
So thank you so much, and also thank you for that questions. I have a very hard task and decision to make now, because we said the time is limited, and I know some of the speakers have to rush into other appointments. So this concludes today's Ecovis International webinar. You will find the email address also in the chat box. The webinar was called the Legal and the Regulatory Framework of Artificial Intelligence, Perspectives from the European Union, United Kingdom, and United States. I think that was very obvious. We hope you all have gained valuable insights into the varying regulatory landscapes that influence AI developments and deployment globally. We'd like to extend our gratitude to our speakers, Roland, John, and Rob, for sharing their expertise, and of course, Ecovis International providing the forum for the 3 presenting firms. Again, if you wish to contact any of the speakers after this webinar, please find them in the chat box. I also like specifically say thank you to Ed Normandin and Kati Hughes for their endless power in making this possible today. Thank you so much. Lastly, thank you to your audience for taking part in this webinar today. Please stay tuned for additional AI-focused webinars from Ecovis International that will follow. We hope you have a great day or evening ahead, or morning, whatever comes for you. Thank you so much. And this would be the end of our today's webinar.